Are your kids aiming for top Ivy League colleges? Are your kids aiming for top 1% scores in SAT or ACT? What is the biggest hurdle? English. To have a strong foundation in English, Test Prep Pundits presents long-term SAT, ACT English program with robust curriculum and experienced teachers. For grades 6 through 10, just $80 a month. Contact us, info@testpreppundits.com, or call us, 844-383-7844.
Fine diamond jewelry is now one click away. Maya Fine Jewels, a family legacy, manufacturing their own jewelry since 1975. Shop online for lab-certified diamond jewelry at Indian prices. Visit your trusted family jeweler, Maya Fine Jewels, at 1315 Oak Tree Road, Islin, New Jersey. Shop online at mayafinejewels.com.
On her big day, she decides how it's going to be.
Get ready to make way for the brides of India.
With Malabar Gold and Diamonds.
సిలికాన్ ఆంధ్ర మనబడి అమెరికాలో ACS 𝐕𝐀 గుర్తింపు పొందిన ఏకైక తెలుగు విద్యాలయం. మీ పిల్లలను 2021-2022 తరగతులలో చేర్పించండి. తరగతుల నమోదు ప్రారంభమైనది. సెప్టెంబర్ 11, 2021 నుండి తరగతులు ప్రారంభం. మనబడిలో చేర్పిద్దాం, తెలుగు భాష నేర్పిద్దాం. మరిన్ని వివరాలకు సంప్రదించండి manabadi.siliconandhra.org, info@manabadi.siliconandhra.org, 1844626 బడి.
తెలంగాణ అమెరికా తెలుగు సంఘం TTA ఆధ్వర్యంలో న్యూ జెర్సీలోని కన్వెన్షన్ అండ్ ఎక్స్పో సెంటర్ లో మే 27, 28, 29, 2022 ఈ 3 రోజులు మెగా కన్వెన్షన్ నిర్వహించనున్నారు. ప్రముఖ
Tvasiatelugu ప్రేక్షకులందరికీ hello and welcome back to our talk show with experts. మనతో ఉన్నారు మన expert Emily గారు. Emily, welcome back to our show. Before we get into our topics for today, thank you so much for being on the show. This program has been brought to you by the Test Prep Pundits. They help you achieve the best for your kids on SAT and ACT tests. They're offering long-term SAT English courses for grades 6 through 10. Also a free mock test as well. Please visit their website for more details. Test Prep Pundits is on a roll. 28% of the students got the top 1% of scores on the October 2nd test. 70% of the test takers got above 95 percentile. So that's amazing and incredible. Thanks to the teachers, students, and parents for their hard work. This program has been supported by movers.com and Malabar Jewelers. Watch us on Yup TV, Facebook, YouTube, Sling TV, World, BBTV, and Dish Network. All right, coming back to you, Emily. Welcome back to our show. It's so good to see you here.
Yeah, thanks so much for having me. Glad to be back.
Thank you. And before we go to the topic, I want to know, and I'm sure a lot of our viewers also want to know, how long have you been working as an immigration lawyer? So just give us a little bit of background on yourself, please.
Yeah, so I've been practicing immigration law for over 15 years.
Wow.
With Reddy and Newman PC, and we are now Houston's largest immigration law firm that handles only employment-based immigration.
Nice. Wow. And I know you have about a staff of about 20 lawyers who are working in your firm. So I
Yes,
can
we
imagine
do.
the amount of, immigration-related cases you guys must be dealing with. Thank you again so much for being on the show today. Let's get back to the topic, the Build Better Back Bill. Build Back Better Bill. Sorry. It's a tongue twister. So, Emily, let us know, will immigration be included in this bill? So there seems to be a lot of confusion with regards to, the House version versus the Senate version of the bill. So can you please explain what is going on with the immigration aspects of this I'm going to call it the BBB bill.
Sounds good. Sounds good.
Okay.
Yeah, so the BBB bill is the reconciliation bill. This is the government trying to get the budget that's going to guide us for the next 10 years. And it has to pass both the House and the Senate. The House passed theirs on Friday. And the great news is employment-based immigration reforms are in the House passed bill. So we've cleared one hurdle. And in that bill, we have the recapture of unused green cards that went wasted. We have the provision to prevent future wastage of green cards. And we also have the ability to file the adjustment of status without regards to the cap if your priority date is at least 2 years old. And we have some additional filing fees as part of that, as well as additional funding to USCIS so that they can actually process all of these applications. So that's very good news for employment-based applicants. On the Senate side, we are stuck. There is no bill yet. What we do have is kind of a plan. Now we're on to Plan C, and this is what the Senate Judiciary Committee has come up with. But they're not putting it into a bill until the Senate parliamentarian confirms that it can be done through reconciliation. We've tried Plan A, we've tried Plan B. The Senate parliamentarian shot both of those down. So Plan C, right now, it focuses on providing parole and employment authorization for undocumented immigrants for a 10-year period, which is not what immigration activists want, but it's better than nothing. And that is what's included in the House bill as of now. What we understand is that the employment-based provisions are not planned to be given to the parliamentarian yet, if at all. I think part of that is due to the fact that it is a kind of everybody's on board with it. It's gone through reconciliation in the past without needing parliamentarian approval. So hopefully, and I think, you know, their, I guess, explanation is they don't want to muddy the waters with the provisions for the undocumented with adding in all of these extra provisions that they want. So I think we should be giving Plan C to the parliamentarian soon, now that we have the CBO score on what this does to the budget and overall finances of the country. And then once the parliamentarian rules on that, if she agrees, then the Senate will actually draft the bill. And then they'll start all doing their amendments. Then they'll put it all together on the floor. And last I heard was we are looking at probably by Christmas. So it's not something that's going to happen in very soon, but should be by the end of the year.
Okay, and Emily, can you please briefly touch upon that Plan C part of it in just a little bit of detail?
Yes, so this is for individuals who entered the U.S. before January 1st, 2011. And it provides them with parole, so they are lawfully present even if they entered without documentation or later fell out of status. And it provides them with work authorization and the ability to travel. So it is, you know, it's not a path to citizenship. You can't move from parole into a green card into citizenship, but it is temporary protection so that you're not subject to possible deportation.
Got it. Okay. Thank you so much for that. All right. Emily, I think you already know what the format is. We're just going to go to our callers, and we have a live chat that's going on, so we're going to be alternating between them. I get a list of questions. So let's take our first caller. Caller with a phone number ending in 7774. We're ready for you now.
Hey, Emily, can you hear me?
Yes, sir, we can hear you. Please go ahead.
Emily, hi, nice to have you on the show, Emily. So my question is regarding the LCA. So, for example, if a person has a full-time employment and he's working remotely, like the job is complete remote, and he has his house address on the LCA, right? So my question is, how many LCAs can be on that house? For example, if 4 friends are living together in the same house, everyone has their own separate room. So how many LCAs can be on the same house? Is there any limit on that? And if there are more than 2 LCAs, would there be a chance of site visit, or how does that work? Emily?
There is no limit on that, but there is always the chance of site visit simply because an LCA has been filed in support of an H-1B petition. So site visits are mostly random, but they're partly based on the background of the company, whether it's third-party placement or that sort of thing. So simply because you have that address listed on the LCA, a site visit really could happen there, regardless of how many LCAs list that address. So I don't think there's any additional risk simply because you're having 4 people that all work from that same location. If you're roommates and all live together, I think that's totally explainable.
Okay, cool. And all the 4 people doesn't need to be on like, for example, if that's a rented house, all the 4 people doesn't need to be on the lease agreement, right? Because that's really up to the who you're leasing it from, what their requirement is. But from the immigration side, no, that's not necessary. Okay, got it, Emily. That was my question. Thank you for the clarification.
Thank you so much for calling, Andy. Let's take our next caller. I have a question for you from Naresh Patel, 83. He says, if a person's annual salary is a little less than what's mentioned in the perm adjustment of status pending, is this a red flag? Can the VO deny the GC because of this in the interview? Does the perm salary have to match, what was provided before getting a green card?
Gotcha. So the perm salary must be paid from the time you actually receive the green card. So it's not mandatory that you be paid that amount now. However, the company does always have to show that they have the ability to pay that salary from the day your priority date is set all the way up until you receive the green card. So if there's a substantial difference or any questions about the company's ability to pay the difference in that salary, it could come up, but I have not seen that happen, especially if it's a relatively small amount.
Okay. All right. Thank you. Let's take our next caller. Caller with phone number ending in 0209. We're ready for you now.
Hi, Nitya. Hi, Emily. Hi. Thanks for your help for our community. Last year, I have a question regarding I-140. Last year, I went for the downgrade EB2 to EB3. And recently, my I-140 is approved, and I have received an approval notice from my attorney. So in that approval notice, there is a section notice type. It is showing as approval notice, and section, there are a professional, that is a section will be there. And consulate, it is showing NVC. Why it was printed as NVC? Is there any issue with my green card process if it is showing like that, a consulate is NVC?
No, not at all. No issues at all.
Okay. Because I filed in AWS in the last year, so I am in the United States, but here it is showing a consulate, so that's what, maybe it's a USCIS typo error, or do I need to contact anything? So
no, since you've already filed the 485, you don't need to worry about contacting anyone.
Okay, so I can ignore this one, NVC. Okay, the text. Okay, and another question I have regarding the EAD. So I am on H-1B, and if I want to travel to India and come back to an advance payroll, then do I need to update any information regarding the I-9 or something if I use the advance payroll for the travel?
If you're maintaining H-1B status at the time you leave and you come back on the advanced parole, but your H-1B petition is still valid and you're coming back to work for the same employer under the same job, same terms and conditions of employment that are on your approved H-1B, you can choose whether you want to be considered to continue an H-1B status or utilize your EAD instead. Either way, you don't have to update anything with anyone. That I-9 only has to be updated when your current employment authorization is actually expiring. So whenever your I-797 petition is expiring, that's the next time your employer is going to ask you for I-9 documentation. At that point, it would either be your H-1B extension approval notice if you decided to continue H-1B, or your EAD card, or hopefully your green card.
Okay. That could be great. And can I use the 2 jobs? One is for H1 for my primary one, and the secondary one, can I use the EAD simultaneously, or do I need to switch
No.
completely on
If
EAD?
you're going,
No?
if you're going to use the EAD to work for a second job, that takes you out of the H-1B unless that second employer files a concurrent H-1B.
Oh, okay. Okay. Thank you, ma'am.
Right.
Thank you.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. And Emily, I have a question for you. This is from Ram Raju. He says, my 485 was filed by my future employer, not my current employer. Got my EAD. Can I stay as unemployed, leaving my current employer for a few months now in the USA? Will join my future employer once I get my green card.
I would not recommend that, and I would definitely talk to a qualified immigration attorney before you choose to go that route to make sure it's not going to cause issues for your 485.
Okay. All right. Thank you so much. Let's take our caller. Caller with phone number ending in 7926. We're ready for you now.
Hey,
Caller with
hi,
number
hi,
ending in
Nitya.
7926. Hi.
Thank you guys for the support, first of all, yeah. And the question is, Emily, like, currently I'm working for an MNC company A. They filed my GC process, or like I-140 started, but currently it is still perm is only not yet approved. But my MPS or the 6th year is ending in 2 months. So what I did was last year, during the same time, I filed for the future employment through company B, and that I-140 got approved. So now I'm having an I-140 approved to company B, but I'm still working for the company A. In the meanwhile, while I'm looking for some company change or something, I got an employment offer from company C. So can I change to company C based on my approved I-140 of company B, provided they won't revoke it? Is it legal or?
You can use that I-140 to work for any employer beyond the 6-year limit, as long as they don't withdraw it within 180 days.
Okay, so even though I don't have any single paycheck with them, that is also okay, right?
Yes.
Oh, okay. Okay. And one more question, like, is it nowadays a lot of times I'm seeing like people working on the concurrent basis of visa on the H-1B. So is it legal to work on the 2 jobs within one H-1B petition with but with 2 different employers, or only one job at a time?
Only one employer. So if you're going to work for 2 different employers, you need 2 H-1B approvals, one for regular employment and one for concurrent. Now, if you're working for one employer on 2 different projects, that's fine as long as all of that is spelled out in the LCA based on work location. But if it's 2 separate employers, you have to have 2 separate H-1B petitions.
Okay. Okay. Thank you, Emily. Yeah.
Thank you, sir. Thank you so much for calling in. Let's take our next caller. Emily, this question is from Manjunatha Lokesh Patel. It says, can we register a personal company on EAD? By keeping EAD for the main approved company and working for that company, also can we register or own or be the director or partner to an overseas company while working in the US on EAD? So let's answer that first one, I guess, first.
Gotcha. So if you have an EAD, you are eligible to use that to create your own company. Whether you would then be working for that company, it sounded like he meant that he would stay with the existing company and would just be starting up a new company on the side. That is fine. And what was the second question?
The second question was, can we register or own or be a director or a partner to an overseas company while working in the US on EAD?
If you are on EAD, yes, as long as you also continue with the company that's sponsoring you or that job remains available. So you can't switch solely to that because you have to still have something that supports your green card process. But as a separate line of business, you could do that when you have the EAD. But if you do that while you're on H-1B, you'd lose your H-1B status.
Makes sense. All right, thanks, Emily. Let's take our caller with the phone number ending in 9929. We're ready for you now.
Hey, yeah. Hey, Emily. Hey, Nitya. Yeah. So, Emily, like, currently I have my I-140 approved, but the due date was like in, the perm date was like June of this year, 2021. So if I have an opportunity in Canada, do you think it would be wise for me to move into the Canada as I have already I-140 approved? I can come back later to US, or because
As your I-1,
earlier,
go ahead. Sorry.
Okay, so because there were some earlier discussions long back, Rahul was referring like maybe by paying 5,000 if you're having like some by 2020, if it was a due date of the perm, and then we can file that 485 and all that stuff. So is it still the immigration bill part of it, or it would be helpful if I stay back, or would it be wise for me to move to Canada? Yeah.
I would give it a little more time to see if the Senate passes the same immigration provisions that the House passed, because then you would be eligible to file your adjustment of status in June of 2023 versus without this immigration reform, it could be a very long time. And so you could pursue a career in Canada for some time and come back later before your priority date becomes current.
Okay. So even if that law comes by 2023, even if I would be eligible, so is it like at that point of time, at the time of filing, I should be working or something in the US itself?
You need to have a job offer from either the company that sponsored your perm and I-140 or from a new company that files a new perm and new I-140 to be able to file the adjustment of status.
Okay, got it. Thank you, Emily. Yeah. Thank you, Nick.
Thank you, sir. Thank you so much for calling. Let's take our next caller, Andy. In the meantime, I have a question for you. This is from UNK. Says if GC-EAD is approved, then does it override the existing H4 EAD, or can we use any one of them as we want? And if so, after expiration of the H4 EAD, can we use the GC-EAD for continuation of a job, that is without extending the H4 EAD?
Gotcha. Yeah, so just because you received the GC-EAD, it does not override the H4 EAD. So if you want to continue with your non-immigrant status, you can continue to utilize the H4 EAD and just have that GC-EAD on the side, kind of on the back burner. If at the time your H4 EAD is expiring, you don't extend it, you can then use the GC-EAD, assuming that it has not expired, to continue working. You just, once you do use that GC-EAD, you can't really go back to H4. So keep that in mind. You'll be married to whatever adjustment of status you have pending.
Yeah. And Emily, would that also mean that the primary on that application will also be assumed to have moved on to that GC-EAD as well?
No, because the primary is also the primary for the status. So a dependent switching status going from the non-immigrant status to an EAD does not impact the primary, but the opposite is not true. If it's the primary that decides to use the EAD, then all the dependents are also married to that AOS.
Makes sense. Thank you. Let's take our caller, Andy. Caller with number ending in 7009. We're ready for you now. Caller with phone number ending in 7009.
Hello.
Hello.
Yep. Hi, Nitya. Hi, Emily.
Hi.
I have a quick question. So what is your prediction on EB3 final action date? Some law firms predicted it will move from March 2022. So what is your prediction?
I don't think anyone can accurately predict it. So I'm sure Rahul has said time and time again that he and I try to predict these again and again, and every single time we're wrong. That was very clear in October 2020. We were way off. And again, in October 2021, we were way off. What we do know is based on the filing date chart as of today, we shouldn't expect to see any EB3 movement until October of next year. But it will all depend on how many people jump back into EB2. And there's just no way to predict that. So people who are giving predictions, I don't know how they can be accurate. It does somewhat make sense that if we're going to see movement, it would probably be happening in the spring or summer, because USCIS is only just now going to start seeing those interfile requests and those refiling for people trying to get back into EB2. And only once they see those, once it materializes, it's going to take several months before they actually start to impact the numbers and using those EB2 numbers. So I know I didn't answer your question, but I don't think anyone can accurately answer it.
Thank you.
Thank you, sir. Thank you so much for calling. All right, let's take our next caller. And Emily, I have a question for you. This is from Nitin Soma. It says, logged the service request to USCIS for GCEAD. Received a response from USCIS on November 4th that I'm in line. I still haven't received my GC. So reached out to Emma, and I've been told that it should be less than 30 days from the point of initial response from USCIS. Can I believe in this hypothesis?
I have not seen Emma recently give a specific timeline for anything, so I'm a bit skeptical. In the past, when you did a service request, they would give you an expected time frame and say, if you don't hear from us within 30 days or within 60 days, reach out again. They stopped doing that since COVID, and they just say, you're in line. They don't tell you how long the line is or when you might reach the front of the line. Yeah. So I'm a bit skeptical that you'll actually receive the EAD within the 30 days. Maybe you'll get a response within the 30 days, letting you know where it's at, which again, they'll probably just say you're in line. I don't put much faith in that.
All right. Thank you for that. Let's take our next caller. Caller with phone number ending in 0424. We're ready for you now. Caller with number ending in 0424. We're ready for you.
Hi. I called you guys earlier, a few months back. Our situation is my husband's EB3 downgrade, I-140 is still not approved, but received our EADs. And our priority date is current in both EB2 and EB3. What is our next situation? What is our next step?
It's the final action date is current in EB2 and EB3?
Both EB2, EB3, that's right.
Okay. Well, although the final action date is current in EB3, obviously they can't approve the green card in EB3 until that downgrade I-140 gets approved. Have you tried upgrading it to premium processing, or is that something your employer is not allowing?
I think 6 or 7 times the premium processing has been not picked up, so that's being tried all the time.
Mm-hmm. Well, I would definitely keep trying that. Your other option, assuming that you've continued to maintain your non-immigrant status from the time of filing, you could file a second 485 in EB2 based on that date being current. Obviously, that case will go in the back of the line in terms of processing times, but then at least you're not dependent on that EB3 I-140 approval that definitely is taking a long time. So it kind of gives you both options.
Right. Unfortunately, the employer is not ready to do a 485 in EB2. So that's one thing we are holding on to.
Mm-hmm. Yeah. So really, your employer, the difficult thing with an I-140 is that only the employer or the attorney can follow up with USCIS. You as the beneficiary, they won't talk to you. So you have to get your employer or the attorney to put in a service request for outside normal processing time, or continue trying to get that premium processing accepted, and then just wait it out for the EB3 I-140 approval.
Yeah, thank you so much. I appreciate that.
All right. Thank you, ma'am. Thank you so much for calling. Let's take our next caller, Andy, and let's get this next question. Question is from Chandana Yeruvaka. She says, I requested for a 797 copy of my I-140 through the FOIA, but but they keep sending me a filing copy, but not the approval copy, that is 797. Can you please guide me on this problem and how I can get the approval?
They won't send you the 797.
Okay.
The FOIA only gives you the copy of the petition filing, not the approval notice. If you're wanting a second copy of the approval notice, if it got lost or something like that, your employer has to file an I-824 application for duplicate approval notice, but you won't get the approval notice through FOIA, and you don't need it either, because the petition copy has the priority date, it has the stamp that says it's approved and when, and the filing date. All the information that USCIS needs is there if you need to use that I-140 for H-1B extensions or anything else.
Okay. All right. Thank you, Emily. Let's take our next caller. Caller with phone number ending in 3268. We're ready for you now.
Hi, Nitya Garu, and hi, Emily.
Hello.
So my question is, currently I am on H-1B visa and my brother is a citizen and he sponsored GC for my mother. So now my mother is having GC. Can my mother sponsor GC for me and my family?
For your mom, so she's a green card holder?
Yes, Emily.
Okay. Let's see here. So are you married?
Yes, I'm married.
Okay. So because of the marriage, you'd actually have to wait until your parent becomes a citizen and then she could sponsor you, because there's no category for married sons and daughters of green card holders. It's only unmarried sons and daughters of green card holders.
Okay. Yeah. Okay. Sure, Emily. Yeah, sure. Thank you.
Thank you, ma'am. Thank you so much for calling. Emily, this brings up sort of an interesting point as to whether people who hold a green card, can they sponsor their parents?
Green card holders sponsoring their parents. So there are the only category that allows sponsorship of the parent is under the immediate relative category, and that's only for citizens.
Ah, okay. So you have to wait till you become a citizen before you can file a green card for your parents. Okay, awesome. Thank you. Let's take our next caller, and in the meantime, let me get another question for you. This is from N.I. Says a self-petitioned EB2 NIW approved, finished my biometrics, approved EAD and I-131 or I-131. Changing job from A to B, what would be the consequences?
So with changing job, so the EB2, because it was self-petitioned, it doesn't require sponsorship. And so as long as you're intending to work in the same field that you received the waiver for, changing the job in between should not have a consequence.
Okay, awesome. Let's take our caller. Caller with phone number ending in 3758. We're ready for you now.
Hey, Nitya. Hey, Emily.
Hello,
Thanks
sir.
for all the help here.
Thank
Am I
you.
audible?
Yes, you're audible.
Am I audible?
Yeah, please go ahead.
Yeah. So I have a question like, if someone after filing 485 and gets married, what are the options for the spouse to get adjusted? Is there an option to do that, or it cannot be done once?
It can be done, but it depends on a few things. So number one, where is the spouse located? If the spouse is in the U.S. in a non-immigrant status, then you look at, is the priority date current, either under the final action date or the filing date, if we can use that chart. And if both of those answers are yes, then you simply file another 485 for your spouse, and you include your 485 receipt notice and your I-140 approval notice, and they will match her application up to yours. They probably won't be approved together because of the delay in submitting that second filing, but that's possible. The other option, if the spouse is outside the U.S. and does not have a way to get into the U.S. In a non-immigrant category, is to what we call follow to join. So that is where you would receive your green card in the U.S. and you file an I-824 application, letting the consulate know that you have a family member outside the U.S. who's going to follow to join you in the U.S. as a green card holder. Once that is processed, they'll be called in for the green card interview at the consulate and then come into the U.S. and receive the green card when they arrive to the U.S.
So you are saying that even the first filing is done as a single, status as single, there is no issue. After getting married, we can sponsor the spouse under 485.
I don't think I followed your question if they're single.
So what you are saying is my understanding correct? Like after filing 485 as single, still one can apply for a spouse if 485 is not yet adjudicated.
Exactly. That's exactly right.
And one last question, like, is there any limit saying that once the filing charts are announced, is there any time limit by when one has to apply for 85?
No, the time limit is you have to file before your 485 gets approved. That's the only time limit. So you are kind of under the a time clock in terms of once your 485 is approved, then you can't file the 485 for your spouse at that point because you're a green card holder now. But beyond that, there's no time limit.
Okay. Thanks, Emily. But this gap, yeah, one last question, sorry. So there is no gap as such, like even after 1 year also, if 485 is pending for some reason, then we can still apply.
Anytime up until your 485 gets approved, as long as the final action date is current or the filing date is current, and we're allowed to use filing dates because she needs to be eligible to file.
Thanks. Appreciate all your help.
Okay. Thank you, sir. Thank you so much for calling. Let's take our next caller, Andy. We have a question, Emily, from Rekha 346. She says, I'm getting an H1B transfer. Can we start the job with a new employer, or do we need to wait until the receipt date?
The petition has to be received by USCIS before you can start working with the new employer. Whether that means you wait for the actual receipt notice to arrive or you start based on the tracking confirmation stating that it's been filed is really up to the employer, because they will decide which of those documents they will accept for the I-9 purposes. Some employers wait until they actually have the I-129 receipt notice. Others are comfortable using the confirmation number.
Okay. Thank you. Let's take our caller with phone number ending in 3921. We're ready for you.
Hello, Nitya and Emily.
Hello, sir.
Can you hear me?
Yeah, we can hear you. Please go ahead.
Yeah. My question is, like, my priority date is April 2012, and I have my EB2 and EB3 approved since beginning. Like since 2012, I have both EB2 and EB3. Now, when October 2020, when I filed my AOS application based on EB3 at the time, October 2020. But in my AOS application, 485 application, I attached my both EB2 and EB3, and I attach a letter to my application that the applicant have both approved EB2 and EB3. So my question is, now my date is going to be current again, the second time from 1st of December onwards. Do the USCIS adjudicate based on EB2? Now I applied on EB3, but my EB2 dates are current from 1st of December. Do USCIS adjudicate based on, yep.
Even though you submitted that I-140 approval, that both the EB3 and the EB2, I would be shocked if USCIS could get their act together and automatically switch you to EB2. Part of the reason for that is when they're doing their data entry, they can only tie your 485 to one I-140. So in the I-485 form, it asks for the petition number. So I'm assuming that your attorney would have put your EB3 petition number. There's not a spot to put 2, and they really can't tie your 485 to the EB2 because that was not current at the time of filing. So I would not expect them to automatically switch you to EB2. I think you're either going to have to interfile or refile.
Oh.
Our government is just not that efficient, unfortunately.
So I need to interfile anyway. Do I need to interfile again now?
Either interfile or refile, yes.
Okay, Emily. Thank you. Thank you very much.
Thank you, sir. Thank you so much for calling, Andy. All right. Let's take our next caller. And Emily, I have a question for you. This is from Janwar Harish. Says, I have a pending AOS with priority date of September 2014. Doesn't look like the GC is going to come anytime soon. Have been using my EAD. Can I move to India and continue with the GC application?
No. You would have to convert to consular processing, so your employer would have to file an I-824 to make that happen. So it doesn't happen automatically while you're outside the U.S.
Okay. Right. Let's take a caller. Caller with phone number ending in 6707. We're ready for you now.
Hi. Can you hear me?
Yes, ma'am. We can hear you. Please go ahead.
Yeah. Thank you for taking my call. Hi, Emily. So I have a question. Like we have filed for 485 last year, EB3 downgrade, but we have a EB2 petition as well, I-140. So since the date has been retrogressed, we are trying to file the AOS application, a new 485 application based on EB2. So the thing is like suddenly my employer told us that this is regarding my husband. He's the primary applicant. So the employer said that they are moving some part of company to with the other name. Say for example, if it is Amazon Tech, and they are moving some of the employees to the Amazon Tech. So it's like so does this consider as a new employer or something? If we want to file the 485 based on EB2, how can we do that? Like, can we use the I-140 approved previously based on EB2? Can we still use that one and file for 485?
It depends. If it's just a name change, you can proceed normally. Assuming that it's an actual change in the corporate structure, which is kind of what it sounds like, the new entity, as long as they're a successor in interest to the original company, which kind of sounds like what's happening, you can proceed, but you need to file an I-140 amendment for the EB2 along with the 485, because the new entity has to prove to USCIS that they are a successor and that they are offering you the same job under the same terms and conditions, and they continue to have the ability to pay. So yes, you can get back into EB2, but it sounds like it's going to require an amendment to be filed, and which can happen concurrently with the 485. Downside is there's no premium processing for that, at least initially.
Okay. So if the tax ID is going to change that, it's still the same process, right? Like you said, we need to do the amendment and concurrently file the 485. Am I correct?
Correct. Yes.
Okay. So yeah, just a follow-up question for this one. Actually, when we filed for the 485, we got the EAD and AP based on EB3. I'm a derivative applicant, but I have my own H1B. So what I thought is I thought of traveling to India, based on the EB3 AP, advanced parole. So if I use my AP while coming back to US, so will I be married to EB3 or so my plan is actually once I come back, I just wanted to do my H1B extension. Because my H1 is going to expire in next 6 months, so I have to anyways do the extension for my H1B. So if I do that, will I be still married to EB3 or I will be on non-immigrant status?
There is an old memo from May of 2000 that says if you're in H1B status when you leave, and you come back on AP, as long as you're coming back to the same job, same employer, same terms and conditions, and your H1B has not expired, you can extend your H1B even though you entered on AP.
I can?
Yes.
Okay. So actually, me and my husband both work for the same company. So my scenario is going to be the same thing. Like I said, the company name is going to be changed. So when I come back using the AP and if they file for the extension, I don't know whether they're going to file for the extension or amendment or a new.
Well, for H1B, assuming it's a successor in interest, it does not require an amendment. They would just file an extension, and then at the time of extension, they document the name change and the successor in interest. It's the I-140 that the amendment is required for, not H-1B.
Okay, all right, got it. Then so I can use AP and come back and then like do my extension so that I will be still in the. So if I want to like file in different category or anything, that won't be any issue, right?
Correct.
Thank you, ma'am. Thank you so much.
Thank you so much.
Yeah. Okay. Let's take our next caller, Andy. I have a question for you. This is from 𝗧𝗘𝗟𝗨𝗚𝗨. He says, my priority date is October 30th, 2015. In EB2, any chances to get current by the next year?
I think it's going to depend on this reform. Okay. Without the reconciliation bill or any kind of immigration reform, I would say probably not, although EB2 is moving faster. Right. Everybody's jumping back into EB2 who downgraded to EB3. So these dates are going to flip-flop back and forth. It's going to slow EB2 down. EB3 might move. So I wouldn't expect 2015 to get there.
All right. Yeah, it seems like, you know, as what Rahul Garu would say, the LA traffic lanes.
Mm-hmm. Exactly.
Right. Let's take our next caller, Andy. Caller with the number ending in 8692. We're ready for you. Please press *6, Andy, to unmute your line. 8692. Please press *6 to unmute your line.
Hello?
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 Hello? Yes, ma'am, we can hear you.
Can you
Please
hear?
Yeah, we can hear
Yeah,
you.
so my name is 𝗔𝗦𝗓𝐿. I just had a question. My I-485 is pending.
Okay. Can you please put your TV on mute?
Sure.
Thank you.
I will, ma'am. So sorry.
No,
Yeah. So yeah, my 485 is pending.
Ma'am, I think your TV line is still on
Okay.
mute.
All right. I think I sorted this. So I'm so sorry about it. So my I-485 has been pending for almost 2 months now, and you know, my employer. This is an employer-sponsored under EB3 category. My question is, you know, I've been listening to the AC-21 portability clause. So after 4 months, when the I-485 has been pending for 180 days, my question is, could I then port this process to a self-employment? I'm a physician. Can I just open my own practice and port the process to my own practice? Will that work?
Your I-140 is approved?
Yes, ma'am. I-140 is approved.
Yeah, so once you hit that 180-day mark, you can move to a new employer, take the process with you as long as the job is same or similar to what you were sponsored for, and self-employment is an option. So as long as you will be, you know, if you were sponsored for a practicing physician role and you will be practicing as a physician now under self-employment, you can do that.
Okay. Thank you so much. I appreciate it.
Thank you, ma'am. Thank you for calling. Let's take our next caller. And I have a question. Let me just, okay. All right. Hold on. I'm sorry. There's a question. This is from Pujita. She says, I came on F1 in 2011 and got stuck in the backlog with a 2015 priority date. Any benefit for legal immigrant in Plan C of the parole immigration reform?
So you'd have to have entered before January 1st, 2011. So you mentioned coming in 2011. Okay. You might have missed it.
Okay. So Pujita, keep an eye on that. Let's take a caller, Andy. Caller with the phone number ending in 5769. We're ready for you. Please press *600 to unmute your line. Caller with phone number ending in 5769. We're ready for you. *6 to unmute your line. In the meantime, let's take another question.
Hello?
Yes, sir.
Hi, yeah, thanks for taking my call.
Sure.
Yeah, so I have a question. So my wife, she is working using H4EAD, and I'm on H1, right? So I'll be moving to a new employer on my AOS EAD, right? So last year we applied for the adjustment of status, right? So I have received my AOS EAD, but my wife, she has not received an AOS EAD yet. It's pending, right? So so she's now working using H4 EAD. My question is, once I switch to the new employer using my AOS EAD, right, can she like continue working using H4 EAD, right?
No.
Until it expires?
No,
Her
because-
H4 EAD expires in Jan 2023.
Even though the EAD doesn't expire, she has to be maintaining H4 status to use it. And once you stop maintaining H1 status, she stops maintaining H4 status. So she'll have to wait until she gets her GC EAD.
Oh, okay. So, follow-up question actually. So once, so once she gets, so she can maybe stop working temporarily, right? And maybe she can take a leave or something like that from her work, and then when she just joins back actually. So how does that happen? So she has a GCEAD. Then should she just the first day of work, should she just go to the HR and just update the I-9? Is that how the process works?
Well, the HR should be contacting her. Yes, once she comes back to work, she will need to fill out a new I-9 or re-verify on the I-9 once she's informed her that she no longer has the H4 EAD, and she'll use her GC EAD for that purpose.
Oh, okay.
But she needs to let the HR know that she's not going to be able to continue working, even though her EAD is not expired, but that she's going to be losing her H4 status so that they can take the necessary action.
Oh, okay. So
like
so
she can't
is it
just
not
on
enough for
her
her to,
own. No, she can't just do this on her own and say, I'm just going to take a leave. No, she needs to let them know, because their policy may be to terminate. It's up to the company whether they will let her take an unpaid leave of absence or whether they terminate and rehire. And so the company needs to be given that opportunity, because it's the company that's going to be on the line for I-9 liability, not her. They could get fined heavily.
Oh, okay. Got it. Okay. All right. Thank you. Thanks, Ash. Thank you.
So thank you so much for calling, Andy. Let's take our next caller, and we have a two-part question from a viewer called 𝗧𝗘𝗟𝗨𝗚𝗨. So the first question he has is that, can immigration medicals be paid by the HSA account? Would there be any problem for the IRS? So that's his first
I don't
one.
see any issue with that. If the doctor is willing to accept those funds from an HSA, I see no problem with that.
Okay, perfect. And his second question is that, how do processing timelines for refiling of AOS compare with the timelines of filing a new AOS? Are they about the same, or does refiling take way more time?
They should be the same. Now, there's no guarantee that they'll be the same, because with a refile, it's possible that once they make it through the initial looking at the file, they may transfer that application to the place where the first file is pending and look at them together, or they may send both files to an officer to do an interview. So that can delay the second filing beyond what would be a normal processing time for a refile.
Okay. All right. Thank you, Emily. Let's take our next caller. Caller with phone number ending in 9890. We're ready for you now. Caller with phone number ending in 9890. Please press *6 to unmute your line. Ready for you. Hello?
Hi. Hello. Can you hear me?
Yes, sir. We can hear you. Please go ahead.
Yes. Hi, ma'am. I have a question. So I'm currently under a H1B status, and my wife is on H4 EAD working. So if I move to new employer, my I-140 is already approved. It's been more than 2 years. So if I move to new employer, so can my wife apply for H4 EAD extension, H4 visa and EAD extension with the previous employer's I-140?
Yes. No problem with that at all.
Okay, how long, can we repeat that, or as soon as I move to new employer, I need to ask my new employer to file new I-140?
No,
It's
she
just the
can
previous.
keep getting EAD extensions based on your old employer's I-140 forever because you waited the 180 days after it was approved. You can keep getting H-1 extensions with any employer using your old employer's I-140 approval all the way up until that final action date becomes current. Then that's the point where you need to have the new labor, new I-140 in place in order to actually file the 485.
Okay. Okay. Got it, ma'am. Yeah.
Right.
All right. And what precautions do I need to take, like, in order to, like, when moving to new employer, do I need to take previous employer's I-140 number and also like perm labor certification also?
You don't have to because you can get it yourself through the Freedom of Information Act. You can do a FOIA request and receive a copy of the I-140 petition filing that'll have the receipt number on it. It'll have your priority date. It'll have the approved stamp, and it will include a copy of your labor certification. Now you can ask them if they'll provide it to you. That's going to be faster and easier. But if they're not willing to provide it, you can still get it.
Okay, got it. And I also need to keep with me previous employers' W-2s and also pay stubs, monthly pay stubs.
Yes.
Got it. Yep. Thank you, ma'am. That's it.
Thank you, sir. Thank you so much for calling, Andy. All right, Emily, there's a question for you from Pradeep R. He says, does the AAC 21 portability clock reset if we interfile on EB2?
There is no guidance from USCIS on that specific question, but there was a practice pointer that was put out by the American Immigration Lawyers Association within the last 2 weeks, and they recommend, yes, that the clock restarts when you try to interfile. So once you interfile, you need to wait another 180 days before you look to change employers.
Gotcha. Okay. All right. Let's take our next caller. Caller with a phone number ending in 1395. We're ready for you now. Caller with number ending in 1395. All right, let's give them a minute to join. In the meantime, I have a question. This is from Cyber Neon. It says, my priority date is June of 2013. Can I interfile from EB2 to EB3 based on the filing date?
EB2, well, the EB3 is already approved, I'm assuming.
I guess so, yeah.
Yeah, so the interfiling, you can only do it when the final action date is current. So the answer would be no, you have to wait until the EB3 final action date is current if you wanted to interfile.
Okay. All right, let's try and talk to our caller again. Caller with phone number ending in 1395. We're ready for you now. All right, let's put the caller on hold, and when they're ready, we'll bring them back. Let's take our next caller in the meantime. Okay, all right. This caller has a number ending in 4203. Caller with phone number ending in 4203.
Receive a copy of the I-140 petition.
Hey,
Hello?
can you hear me?
Yes, sir, we can
Yes,
hear you.
you can hear me?
Yeah, we can hear you,
Yeah,
sir. Can you please mute your TV line?
Yes, I am. Yeah, thank you.
Thank you, sir. Go ahead, please.
Yeah, so I have a pending 485 filed under EB2 this October, and I have a new offer that requires me to start in January. So can I ask them to file a concurrent H1 for 40 hours, like full-time concurrent H1, which can act as a bridge until I cross the 180-day mark without premium processing? That way, they don't have an opportunity to reject it right away. And it acts as a bridge for me to get to the 180 days.
So you'll keep working for the current employer during that 180 days?
Yeah, I'll be working for the current employer and the new employer for until April 7th or 8th, until I cross the 180-day limit. And then I'll resign from my current employer and work full-time for the new employer.
Yes, you can do that. Mm-hmm.
All right, thank you so much.
All right. Thank you, sir. Thank you for calling. Let's take our next caller, Andy. And in the meantime, Emily, I have a question for you. This is from Bapi Reddy. says, is it okay if the existing I-94 expires on a certain date and the new approval of the I-94 comes from the next day without overlap?
No problem at all.
Okay.
Yeah, the start date on those approvals, sometimes they're even months in advance if the petition was pending for a very long time. The most important thing is that it's approved and there's an I-94 on it, but the start date being not overlapping is fine.
Okay. All right. Let's take our next caller. Caller with phone number ending in 4921. We ready for you? Oh, a bit of a problem with that. Let's, I think we ran into some technical issue with that. Caller, let's take our next caller early. All right. Caller with phone number ending in 9058. We ready for you? Caller with number ending in 9058. All right. While we're waiting for the caller, I have a question. This is from Hawaiian Islands. Says for EB 485 interview, is it okay to carry a photocopy of the 797A and W2 from 2014 as I'm not finding the originals of the same?
Yes, for any immigration documents, your approval notices, I-94s, you can bring copies of. The only thing that you need the original for is birth certificate, marriage certificate, passport.
Okay, thank you. Let's try this caller again. Caller with phone number ending in 9058. Please press *6 and to unmute your line. Caller with number ending in 9058. Press *6 to unmute your line.
Hello?
Okay. Hello?
Yeah, can you hear me?
Yes, sir, we can hear you. Please go ahead.
Hi, Emily. I was looking, I did a downgrade in October 2020. And, my priority date is August 2011. I see that USCIS has only adjudicated 800 GCs. So,
hello?
Yeah, so is USCIS going to adjudicate these cases soon, or should I file a EB2 new because I'm current in EB2 also?
Well, it's not unusual that USCIS is slowing down their adjudications at this time. Usually it is quite slow this time of year. Couple reasons for that. Number one, when we saw the big surge and they were hurrying up to approve applications in the summer, August, September, they cannot maintain that pace, according to them. So that was just a temporary measure to try to approve as many as they could before the green cards got wasted. Now that we're into the new fiscal year, it's back to the same old where they're slowing their pace down, worrying about other things. And at the same time, they don't, one of the slight factors here is the spillover and the spill down. So EB1, any unused EB1 green cards spill down to EB2. And then any of those that the rest of the world does not use in EB2 spill across to India. But they can't start using those spill across because they don't, if they start using them and then rest of world people start filing, now they've messed up their numbers and they've gone over the limit for India. So they can't approve as many as they would towards the end of the year to make sure that they leave enough available for the rest of the world in case there's people in line. Now we all know there's nobody in line, but that's kind of their rationale. So yeah, it's not unusual that the numbers dropped way lower than what they were in the summer and fall.
Yeah, for October 20 filers, like they are adjudicating 1 case, 2 cases, 3 cases a day because I'm following up and, seeing the data and all those things. They're doing like 3 or 4 approvals, 5 approvals. Someday it is 1 approval. So we are, see, the 5,600, whatever Charlie said, are they even going to use that? Because they are giving very randomly. They are giving to people who are above my, above my date, and for people, I submitted my medicals, they are giving RFEs for people who did not submit medicals, and they're approving for 2012 people who are not even current. So is there anything we can do to tell them, hey, you know what, you are jumping the lanes, why don't you give in such a lane? So can we do anything to make sure, because I don't want to file another case in EB2 and just wait there and here and there?
Yeah, I don't think there's much we can do. You know, perhaps reaching out to the ombudsman, but they really, you know, they say they follow first in, first out.
No, ombudsman, I reached out to ombudsman also, Emily, but the thing is, they are just saying we are
more of
processing.
a holistic, right? That's the thing is
Yeah,
this is a government agency. We can't force them to do anything. Although they're supposed to be doing first in, first out, there are many factors that go into that, such as final action date being current, which local field office they get transferred to, if they get transferred at all, if they're still going to the National Benefit Center. There's just so many moving parts that you can't say that it's, you know, someone who filed after you got approved first is not right. So I think that's the difficulty. They would be able to defend any kind of way they process that they want to because they're a government agency and it's their job to use their resources how they see fit. So I think it'd be really tough to get them to do anything different. The good thing is in this House bill, and hopefully the Senate passes it, there's a lot of funds that are being made available for USCIS to allow them to actually build some efficiencies and improve the process and improve processing times. So maybe we'll see some benefit there. But I definitely understand where you're coming from, but I just don't see much that we can do other than following up with their own
day in,
case.
day out, like frustration, like, you know, we're unable to do our job, like not just with me, like, you know, there are so many people who are frustrated every day, like, you know, we see so many things are happening. They're approving 1 GC and 2 GCs in downgrades. I don't know what kind of sin we did or what.
Yeah, sir, we totally understand your frustration. Let's take a few more callers. If you
Thank you, Emily.
Thank you so much for
holiday.
calling us, though. Yeah, thank you, sir. All right, let's take our next caller, and I have a question. This is from Hari Raj. He says, I'm a derivative and I got my EB3 EAD advance parole while my spouse, who's the primary, is still pending. Am I allowed to use my EAD and AP card, or should I wait till the primary gets his EAD or AP card?
You can if you, so if you use it, it doesn't impact the primary applicant's status, assuming that the primary is also the main applicant for whatever visa status you're on, or if you're on independent statuses. So you using the EAD as the spouse would not have any impact on your spouse who doesn't have the EAD yet.
Okay, perfect. Thank you, Emily. Let's take our next caller. Caller with phone number ending in 1395. We're ready for you now. Please press *6 to unmute your line. Caller with phone number ending in 1395. *6 to unmute your line. All right. Let's put this caller on hold and take the next caller, Andy. All right, All right, caller with phone number ending in 4702. We're ready for you.
Hello.
Hello.
Can you hear me?
Yes, sir, we can hear you.
Hey, Emily, I have the same question as the previous caller. What more can we do? Like, my priority date is EB2 2010. I've been waiting since October. Everybody around me is getting green and no word, nothing yet. So reached out to congressmen, ombudsman, raised SRs outside normal processing time, and whatever you spoke about, the field office, the receive date, the notice date, everything matches up with other applicants. Till there's no movement.
Right. Yeah, unfortunately, I think you've done everything that you can and just keep doing those things. The one thing that you haven't done is litigation. And our experience is litigation is very difficult to be successful in this type of case. And the reason for that is the way the statute is written, it says that the Attorney General may adjust the status of someone who's already in the U.S. It doesn't say must, it says may. So the courts take that as the government has the discretion of adjusting status and they get to decide when they're going to do it. So they don't consider it to be unreasonable until it's been several years and there's just no answer from USCIS on that. So unfortunately, I think that you've done everything you can do and just keep doing those things.
So my other part of my question is, I mean, I have seen you and Rahul both say good things about these bills, but if the dates have moved just for 3 years and we see such a mayhem, what happens if the dates progress to 2018 and with me being a priority date of 2010 still stuck while somebody in 2018 getting greened?
Yeah, totally get that.
So how would we justify that?
Well, this bill also includes $28 billion, which the House specifically says is to get through the processing of both the undocumented, the Plan C provisions, as well as the recapture provisions. On top of that, the effective date of this bill wouldn't be until May of 2022. So they should hopefully be getting through those that are already current during that time. Now, I'm not holding my breath. I'm not saying that they are going to be great at this. We all know, you've all been dealing with this for years. You know that nothing is perfect and things don't go how we would like them to do. It doesn't seem to make any common sense. But that's kind of what we have to hope for, is that the additional funding will allow them to hire more officers and get cases moving faster and through the processing time before we start adding all these additional people into the pool.
Yeah, let's hope so.
Yeah. Sorry, sir, we totally understand your frustration, and we have been in the same boat. But thank you so much for calling in. I know we have a lot of callers waiting and a lot of people on the live chat as well who are waiting to speak with you, Emily. But unfortunately, we're all out of time today. But hey, viewers, you know the drill. Same time, same place. Next week, we will definitely see you back again. Emily, thank you so much for being on the show today with us and, answering all these questions very directly and to, sort of let people know. I know a lot of people are frustrated at this point. But thank you for helping alleviate some of their concerns and also in understanding that they're not alone in this and that, there's a ton of people who are struggling with them in this fight against the immigration system. But thank you so much again.
Absolutely. Glad I could be here.
Yeah. And happy Thanksgiving to all of our viewers. We'll see you next Sunday at the same time. Have loads of turkey, spend loads of time with your family, and be happy. Thank you. That's all for today.
Are your kids aiming for top Ivy League colleges? Are your kids aiming for top 1% scores in SAT or ACT? What is the biggest hurdle? English. To have a strong foundation in English, Test Prep Pundits presents long-term SAT, ACT English program with robust curriculum and experienced teachers. For grades 6 through 10, just $80 a month. Contact us, info@testpreppundits.com, or call us, 844-383-7844.
Fine diamond jewelry is now one click away. Maya Fine Jewels, a family legacy, manufacturing their own jewelry since 1975. Shop online for lab-certified diamond jewelry at Indian prices. Visit your trusted family jeweler, Maya Fine Jewels, at 1315 Oak Tree Road, Islin, New Jersey. Shop online at mayafinejewels.com.
On her big day, she decides how it's going to be.
Get ready to make way for the brides of India.
With Malabar Gold and Diamonds.
సిలికాన్ ఆంధ్ర మనబడి అమెరికాలో ACS VASC గుర్తింపు పొందిన ఏకైక తెలుగు విద్యాలయం. మీ పిల్లలను 2021-2022 తరగతులలో చేర్పించండి. తరగతుల నమోదు ప్రారంభమైనది. సెప్టెంబర్ 11, 2021 నుండి తరగతులు ప్రారంభం. మనబడిలో చేర్పిద్దాం, తెలుగు భాష నేర్పిద్దాం. మరిన్ని వివరాలకు సంప్రదించండి manabadi.siliconandhra.org, info@manabadi.siliconandhra.org, 1844-626-BUDDY.
తెలంగాణ అమెరికా తెలుగు సంఘం టీటీఏ ఆధ్వర్యంలో న్యూ జెర్సీలోని కన్వెన్షన్ అండ్ ఎక్స్పో సెంటర్ లో మే 27, 28, 29, 2022 ఈ 3 రోజులు మెగా కన్వెన్షన్ నిర్వహించనున్నారు. ప్రముఖ వ్యాఖ్యాత సుమా కనకాలతో పాటు మరెందరో సినీ రాజకీయ ప్రముఖులు విచ్చేయనున్నారు. అంతేకాదు ప్రముఖ గాయని గాయకులతో ఎస్పీబీకి ఘన నివాళి, కప్రిసియో బ్యాండ్ మరియు వైవిధ్యభరితమైన ప్రత్యేక కార్యక్రమాలు ఆహుతులను అలరించనున్నాయి. ఆటలు పాటలతో సినీ తారలు, బుల్లితెర నటీనటులు, జానపద కళాకారులు అందరికీ ఇదే మా సాదర ఆహ్వానం. ఫర్ మోర్ డీటెయిల్స్ ప్లీజ్ విజిట్ www.tdaconvention.org.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour, or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info at Test Prep Pundits. Call at 844-383-7844.
A new wave in the test prep. Test Prep Pundits offer SAT, PSAT, ACT just for $499, with powerful teachers, with top 1 percentile tutors, and powered by stellar digital curriculum. Contact us at info@testpreppundits.com or call at 844-383-7844.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్, $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి ఫస్ట్ యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TV Asia Telugu.
అమెరికాలో నూరి ఫౌండేషన్ ఆధ్వర్యంలో సర్వాంతర్యామి అయిన శ్రీ షిరిడి సాయిబాబా మందిరాన్ని 2001 జూలై 4న బాల్విన్, న్యూయార్క్ లో, మార్చ్ 2008 ఇస్లిన్, న్యూజెర్సీలో నిర్మించారు. భక్తుల కోరిక మేరకు ప్రతి ఒక్క ఉపాలయంలోనూ అన్ని సన్నిధులను ప్రతిష్ఠించడం జరిగింది. ఎంతో అనుభవం కలిగిన పూజారులతో కార్యక్రమాలను నిర్వహిస్తున్నారు. ఇక్కడ కేవలం పూజలే కాకుండా పిల్లలకు బాల వికాస్, సాంస్కృతిక కార్యక్రమాలు, రక్తదాన శిబిరాలు, అన్నదాన కార్యక్రమాలు మరెన్నో నిర్వహిస్తున్నారు. భక్తులందరికీ ఆహ్వానం. ఫర్ ఇస్లిన్, న్యూజెర్సీ మందిర్, మోర్ ఇన్ఫర్మేషన్ ప్లీజ్ విజిట్ www.shirdisaiNJ.org. And for New York Mandir information, please visit saimandirus.org.